Okay, so folks at Penn State felt better because they complied with their own IT security policy. And of course, this security policy accounted for all of the government security controls, right? Hello, it's Jacob Hill with GRC Academy. Today I'm here with a very special group, and we'll get to that shortly. And folks, if you're enjoying the podcast, please take a moment to like, comment, share, subscribe, review, all those things. Really helps me out. Thanks in advance. Why don't you all introduce yourselves? Go ahead, Julie, you start.
I'm Julie Bracker with Bracker Marcus LLC here based in Atlanta. We're False Claims Act attorneys and indications nationwide, and have gotten very much into the civil cyber fraud initiative space lately.
I am Matthew Decker. I am the Chief Data and Information Officer at the Jet Propulsion Laboratory in Pasadena, California, formerly the Chief Information Officer of the Applied Research Lab, and for a brief period in time, the interim Chief Information Officer and Vice Provost for the Pennsylvania State University.
Thank you so much for coming on. Julie, give us a little bit of the timeline and how this kind of originated and to when it eventually settled.
Yeah, just to reiterate, these are all allegations. Nothing in here should be construed as being, proven or established in court. That process was not completed in this case. Yeah. And of course, nothing on this podcast should be interpreted as legal advice. The Penn State case was actually the second of the two cyber fraud cases that have kind of been vying for first in so many ways. We had the Georgia Tech case, which actually I filed first. Very shortly thereafter, Matt reached out and we put together and filed the Penn State case. They're both very similar in that they're against academic research institutions who are not making sure that principal investigators are properly taking care of government controlled and classified information. So Penn State came out from under seal first because the judge in the Penn State matter decided that they had had enough extensions and it was time for the case to be public. The Georgia Tech judge, meanwhile, gave more extensions to the investigators on that end, and so we continued under seal there. Then the Georgia Tech case was unsealed, and the government, they intervened. They were given a period of time to draft its complaint and intervention, and meanwhile, back in Penn State, the magistrate judge agreed to hold our case and allow the government to finish its investigation. So during that time, it was very much like a holding tank that the normal government intervention decision-making process where we normally sit. But in this instance, everybody knew about it. So that was a little strange. But, lucky or not, Matt was spared the seal very quickly in this case. Georgia Tech's complaint and intervention was filed on Monday. And then that Friday, we announced the settlement in Penn State matter. It was a very eventful week for the Civil Cyber Fraud Initiative and for Bracker Marcus. That's sort of the overview of how those two cases have run naked back as we've proceeded through the court system.
Well, that's very interesting. We'll dive into a little bit more detail on that in a moment. Well, Matt, tell us about your role at Penn State. What did you do there?
So I was originally recruited to come to Penn State in the capacity of the Chief Information Officer at the Applied Research Lab within about a 2 or 3 week span from showing up in Pennsylvania. I was asked to consider being the interim Chief Information Officer and Vice Provost at the university as well. Coming to Penn State was an interesting adventure. I knew that in May there had been a successful breach via APT to the College of Engineering, College of Liberal Arts. The recruiter that was talking to me also knew, this is something you could probably come and help us with. The laboratory is certainly being targeted and the university could certainly use help as well. So interesting times for sure to be recruited to Penn State, but those were my initial roles.
Well, that's very interesting, Matt. Talk to us about how Penn State is organizationally structured.
I think Penn State is typically following the organizational structure of many research universities. You have your different colleges, you have your different administrative, academic, and research areas as well. Problematic to that, I think you'll find in a lot of universities is that there's a disparate organization of IT information environments or resources. In Penn State's case, spread across 24 campuses, and at the time, 84 different IT units made it certainly an interesting environment to try and figure out, are we secure? Are we compliant? Let alone efficient and effective?
And in your role, were you over all of those different units or just a specific unit?
Yes. In my role as the VP and CIO, That was my responsibility. All the IT units, all the personnel, the budget across the 24 campuses and 84 IT units. So that was part of the initial challenge too. I had not intended to stay at Penn State proper in that role. I was there to help in a temporary basis transition to new leadership. But part of that required that we needed to be financially stable. We needed to have some semblance of standards and metrics that we were using universally to make sure we knew how well we were doing, and in particular to things like compliance, performance, and also making sure that we were organizationally aligned for the next chapter at Penn State.
Obviously, you learned there were problems. How did that come about? Like, what were the first indicators that there was a fire, right?
Let me preface first by delineating between the Applied Research Lab and Penn State. The Applied Research Lab was hyper aware of DFARS. So 7012 was at top of mind at the Applied Research Lab. It was really a tale of two cities, where the Applied Research Lab chief financial officer, chief security officer, they had a mind around 7012. They knew it was going to take some heavy lifting, and they were on board, very, very supportive. I can't say enough about the leadership team at the Applied Research Lab. However, at Penn State, as you can imagine, having such a dispersed, organization, it was a constant battle to educate people on what is 7012. And by the way, what's the CMMC that's popping up? Making sure that people understood, hey, when you're signing these contracts, this is what you're signing up to, specifically with DoD contracts, citing the protection of CUI information. It was a constant battle, having continuous engagements with Vice President for Senior Research, all the way to the interim CISO. It was probably important to say that the CISO at the time was also interim. And then talking to the different research units too that were responsible for signing off on the attestation of compliance.
So when you're having your meetings, you're trying to get people on the same page and all those things. You're still not getting down to the level where the actual work is happening. What level of certainty can you have at that level?
Well, the fun thing about me is I started in the trenches. I'm a technologist. I really enjoy information technology and cybersecurity. I know it fairly well, and I really resonate with the people that are doing it on a daily basis. So I've got the bottoms up perspective as well as the top down perspective. And it was actually pretty frustrating when I would talk to the people that are at the upper layers and hearing everything's fine. I don't know why you're bothering to check into these things. And then talking to people that are literally in the trenches saying, hey, look, we really have a problem over here. I need to talk to you about this. So that just really added fuel to the fire of, hey, we really have a lack of consistent awareness within the university. And I might even point out too, that Penn State has been going through very interesting periods of change over time. In fact, since I left the interim VP and CIO role, there have been 8 now CIOs that have taken place. So you're averaging about a CIO a year at that point.
Wow.
It's really hard to build the repetition. It's hard to build that muscle. It's really hard to maintain that awareness across the board. Very frustrating for people that are trying to get the work done too, when you have this instability of leadership and even changing goals and perspectives.
Well, talk to us about the issues that were in the complaint. What did you see?
The issues in my complaint were really around the fact that there were contracts that were being signed for some pretty sensitive work. I won't really get into it. I think if you want to read the case, you can do that. I think the information that's publicly shareable is there. But certainly, sensitive military research information was available, and it was existing on environments that had been successfully breached at one point in time. And if you really know your way around APTs, they're persistent. Right? It's by definition, they're persistent, and I don't believe they're gone. And so putting information in an environment that has been previously breached and probably not thoroughly addressed, as well as not meeting the basic elements of compliance, things like being FedRAMP certified for cloud solutions, was a very scary situation. It really came to a head, though, when the enhanced DFARS 7019 showed up, and I began the educational campaign of explaining, hey, now you have to have system security plans, and you also have to record them, the results anyway, of your SSP evaluations in the SPRS system, the Supplier Performance Risk System. Again, having to do this continuous education with Penn State and getting them to understand why contracts were being frozen. Well, for example, a prime contractor would say, hey, I'm looking into ExoStar right now, and I do not see that you are compliant within SPRS. And so miraculously, records start showing up against plans that I never got to see. I think at some point it was pretty apparent when it was told to me. Hey, I was just trying to check the box. We were comparing what we would think would be on an assessment to our what we called the 8095 template, which is not NIST based. So all of that really kind of boiled up into: are we falsifying records? Are we talking about security plans that don't exist?
So you mentioned these different units are submitting SPRS scores. Should there be a validation chain that these scores are vetted through before submitting to the government, in your opinion? What's that perfect picture look like to you?
So I had proposed at one point in time that the university establish a CUI working group. It was clear that we needed to make sure that the right stakeholders were in the same room talking about what does this mean? And what are the risks to the university? And what can we do to validate and improve what our scores really are? That did not gain traction. That was really largely dismissed as, no, we've got this. It's fine. We have 8095. Things are great. We just signed the contracts. Things are going to be okay. But I think that it needs to be a process of validation with those key stakeholders. It needs to be the Office of Research Protections. It needs to be the legal counsel. It needs to be contract management. Those people need to be involved. And they also need to include the people that are responsible for implementing these technical controls.
You mentioned, was it 8095? What is that?
8095, if you look into Penn State a little bit, you'll find a lot of their administrative policies follow this 80 nomenclature, and 8095 was their security policy for configuring systems for the College of Engineering, for research environments. And again, at the time, before DFARS was a thing that had a lot more definition, particularly around NIST frameworks, that was about as best as they could come up with at the time, but completely insufficient for what the actual requirements are.
Interesting. So some standard they set up,
right,
but it didn't account for the NIST requirements, but they still thought everything was great.
If anybody wanted to, they could also go to the Penn State site and pull down 8095 and do a crosswalk with NIST 800-171. I think you might find the results are very interesting.
And in some ways, I think it even made it harder for Matt to get traction because there was this existing policy that had been in place and people were confident in it and the notion that it had evolved. So that was a lot of the uphill battle that we alleged in our complaint. I'll say this is all allegations, right? It was never tested for truth, but these were all allegations. And that uphill battle, when one group is saying what we have with 8095 is fine, and then Matt saying it's not, well, you want to believe the guy that's not going to cost you any more money, right? I'd rather know it's lateral for. I like that answer, but
the PIs were frustrated too. The Penn State researchers are phenomenal. They are some of the most brilliant people you'll ever meet, and they really trusted the leadership at Penn State to make sure that they were checking all of the boxes appropriately, right? And making sure that the environments that they were doing research in were compliant. They really didn't want to, nor were they funded really, to go and start over and establish compliance. And so very frustratingly to these researchers who understand government contracting too, nomenclature started to be used at Penn State that was very misleading, where you would have people within the cybersecurity group say, hey, this environment, it follows 8095 and it has an ATO. And that means a lot to people that work in government space. Having the authority to operate means that there has been some level of formal adjudication of your security requirements, controls, and validation. And when they hear, oh, I have an ATO, they would even share with their sponsor, I have an ATO. Contract officers on the government side hear that differently as well. And so it just became this giant confusing ball of really non-compliance.
I bumped into that, especially from the government perspective, working with vendors, and there's one situation I was dealing with. Well, it's an appliance. Don't worry about it. It's just an appliance. It's a hardened appliance. I'm like, I don't know about that. let's dig into it. And we found things because we took the time to dig into it. But for people who aren't security oriented, or maybe they're not, I don't know, engaged, or they just don't want to apply themselves and put in the work to verify and validate, you get to problems exactly like this,
Exactly.
You do. And it's frustrating for those people that do understand it, and they're working so hard to make sure that those controls are in place. They want to see Penn State succeed. They want to see the research being protected, and they work very hard to make sure that those things are understood. But at some point, they run into these brick walls in the layers of bureaucracy that reach a point where, well, this is going to cost us money, or I really don't want to take the time to understand it. Or, if I hold my breath long enough, either I'll cycle out and I don't need to care, or something will change and we won't need to care collectively.
I was just going to mention, I think with both the Georgia Tech relators who were able to talk with you before and with Matt, one of the things that I had to have that very hard conversation with everybody wasn't actually as hard as I was worried it would be, that because these are potentially arms of the state, they might plead for 11th Amendment immunity. And so we might be doing this for nothing. And by nothing, I mean for no monetary reward that would normally apply to an FCA case. And I'm more than willing to front my fees and front my potential recovery for protecting. I'm from a military family. My husband's from a military family. We do not want to see these secrets shared. We don't want to see the IP distributed. We don't want to see foreign adversaries getting hold of this stuff. And I'm happy to do that work, but to ask somebody else to do that same thing and put their career on the line, is tough. Yeah. And one of the things I was hoping that Matt could speak to while he's here is why he did that. I know there's people out there listening who are probably kind of evaluating the same thing. And if you're not, again, the 11th Amendment issue is peculiar to potentially state-related entities. And if that's you out there, then call me and we'll talk. It doesn't apply to the majority of these situations, but coincidentally or not, it doesn't apply to, so the Georgia Tech Research Corporation is the management company that takes in all the grants and signs the grants for Georgia Tech, and they're separate from Georgia Institute of Technology. So we're in a little bit different position, and I think that may be one of the reasons the two cases are going differently or were treated differently. But I just thought that it might be a good time for Matt to speak to with that much uphill battle, a lot of people would walk away. And I've been so honored to represent Matt in this case because of that, because this is a hard decision to make, I think.
From a career perspective, it's a lot more uphill than people might think. When I first talked to Julie, she informed me, hey, because Penn State is related to the Pennsylvania state government, there's a real good chance there's just really nothing in this for you. So I needed to be very clear about that, about what I was getting ready to do. But I have dedicated the majority of my career to national defense and protecting our systems that protect our nation, that protect our warfighters. And I also have a level of culpability. If I'm aware that something hasn't been right, it's everybody's responsibility to do something about it. So this was, I guess, me taking a proverbial bullet for doing the right thing. So I filed my case. I left my job. I have moved away from my family and home in Pennsylvania. They're still there, and I'm out here in California by myself. And it's not been a pleasant experience for sure, but it's not about making money off of this situation. It's not about getting even with somebody. It's about correcting a situation. And if I was not able to correct it from a grassroots level, and I was not able to influence it at the very top, then there's a real problem and I need some help. And I think a lot of people might find themselves in similar situations too, particularly in leadership roles. And you really need to think about eventually, what is my level of culpability here? If I had awareness, if I chose to do something that wasn't quite right, or if I just decided to look away, is that really the right thing to do? You might get away with it, but think about what you're jeopardizing.
Hey everyone, Jacob here. Let me tell you about today's sponsor, Vanta. As the number and severity of third-party breaches continues to rise, companies are increasingly vigilant, not just about how they handle their own data, but how their vendors do as well. For security and compliance leaders, this means more security reviews are coming across your desk every day, and valuable time is being wasted on manual security reviews. With Vanta questionnaire automation, security and compliance teams teams can complete security reviews up to 5 times faster, giving you time back to focus on running your security and compliance programs. Over 8,000 global companies like ZoomInfo, Smart Recruiters, and Noibu use Vanta to save time on security reviews. Visit vanta.com/GRC Academy to learn more about questionnaire automation. That's vanta.com/GRC Academy. Thanks and enjoy the rest of the episode. So how do you work internally in Penn State to try to get these issues resolved?
Something that everybody out there should be aware of as well if they're in this situation, and something I'm confident in Matt's discretion, but I want to just remind everybody what's going on here. When you are working for Penn State, in this case, and you hear things from internal lawyers or even outside counsel, you're part of that organization, and so you're covered by their attorney-client privilege. So one of the things that I have to be very careful with when I talk to whistleblowers is talking about what do they know separate and apart from what they've been told by counsel. Now, most of what you're seeing, if you're a cyber professional, has nothing to do with the lawyers. But what I don't want to know is and then the lawyer said to me, no, stop there. I don't want to see documents from lawyers. I don't want to hear conversations with lawyers. Don't want to hear it. The DOJ does not want to hear it. That's going to be true across the board, no matter who we're blowing the whistle on. So how that plays out here is Matt knows, because we were very careful in how we did our complaint and disclosure statements, that we don't share that information. But that's going to hamper what he can say about what he did internally, right? Because, of course, when you complain about we had liability, people roll out the lawyers.
Getting my arms around the university and the areas where we needed to focus on compliance issues started with a conversation with the Senior Vice President for Research, who's no longer there, Dr. Neil Sharkey, for a kinesiologist, PhD. He had pretty good awareness of what our risks and what our opportunities were in terms of defense research. And so one of my initial meetings was with him. He was very worried. He said, look, I understand how big this could be. I know what kind of changes this could bring to the university. I'm really looking for some help in figuring out how big is this problem that we have right now? How much work will we have to do? What kind of a timeline are we looking at? Who should we involve? It was a great conversation. And so then that led to having conversations with the interim CISO and starting to form some committees. I had the ability, right, to pull people together because I said we needed to, and begin these monthly conversations about where are we? And hey, by the way, I have another job I do at the same time over at the Applied Research Lab. I'd really like to compare notes from a contracts perspective to a controls and implementation perspective. Let's talk about what's different here and how do we get on the same page? Those efforts started to fade away as I stepped back from the university until they just eventually disappeared. The opportunity continued to surface, though, as I continued to work with the university in my role at the Applied Research Lab, looking at contracts and saying yes or no, we are or are not compliant and can or cannot do this work. It kind of culminated to a point, too, where I said, hey, look, let's just talk about your cloud services. You deployed Microsoft 365, you used the commercial version, and you're storing the CUI on there, and that's a problem. So let me help you. Let me bring in Microsoft. I think you had Richard Waitman here recently. I had a conversation with him about, hey, how can I architect the Penn State environment to include the Applied Research Lab as a tenant and Penn State as they needed to as a tenant as well? How could the Applied Research Lab operate that and allow a research in that encompasses CUI information? That's a significant financial investment. That's a significant level of effort in the smart people over at ARL and their peers at the university. And unfortunately, as inviting as that sounds, it didn't get any traction. Just the same as putting together a CUI working group. There was just no interest, and I could not believe it.
Wow. And so you try, and then at some point, how do you find Julie?
Eventually, you bump into a couple of contracts that mean something to the then Senior Vice President of Research, who is very much focused on increasing the research expenditure dollars year over year. I think the goal was we really want to hit $2 billion a year. And when you get little old me standing in the way of maybe some NASA contracts, that becomes problematic to somebody who's really focused on getting those numbers up. I was asked to form a tiger team and dig into, okay, just tell me how wide and how deep this problem is. And so I did. And the question came back from the university, should we just stop accepting contracts right now? This looks pretty bad. And unfortunately, the response at the top was, I think he's just kind of crazy. I don't know that he knows what he's talking about. And I think we can ignore him. Wow. But I'll have him take another shot at it. So we started another tiger team. And that's when we found the questionable SPRS records. And when I reported that, that's when it was time for them to pull me off of the tiger team leadership and put in the back seat. So when I realized the character assassination was taking place and I didn't see anybody at all at Penn State coming to defend my position, I knew I wasn't going to get anywhere, and it could have been detrimental to my career.
Wow.
That's when it was time to reach out to Julie.
Wow.
I participated in a JSON study in 2017 talking about the challenges of protecting sensitive government research information in public research universities. So I know there are a lot of people interested in how difficult it can be. And I don't think that Penn State is alone having these challenges.
When someone's trying to describe what's a university like from a security compliance standpoint, they say it's like a municipality. So what is interesting to me is, because I come from a small business perspective, and I know there's all kinds of small businesses with this same exact problem, but you got to basically see from the top what it almost like what's equivalent in a way to 84 small businesses. You know what I mean? And it's difficult because they say the same thing. Everything's fine. Everything's good, but it's not. There was a very interesting article I was reading that was highlighting the consolidation of all these businesses into the big mega primes that we know today. And I think, unfortunately, that's probably going to happen again because small businesses haven't prepared. They haven't done what they need to do to get compliant and to prepare for CMMC certifications.
And that's something that we saw at the Applied Research Lab. When COVID hit and I had a little bit more time working remotely to focus for longer hours during the day, we put together a supply chain risk assessment that was based on compliance. And, funny thing is, a couple months after we put ours together, NIST came out with a similar model that looked for things like, hey, what's your past performance look like? Are you registered in the appropriate place? Do business with us. And, let's take a look at your system security plan and help you pinpoint where you're going to have challenges in meeting our flow down requirements.
From the whistleblower perspective, the size of the company doesn't matter. The academic versus private company doesn't matter. This is a story that's just repeated over and over. I have sympathy for some people. They're the ones who are trying to do the right thing, and maybe they've got resource issues, and maybe they got bad advice early on. If your main line is government contracting and you said you were compliant, you don't slip and say you have a 110, right? You decided to say you have a 110.
Yeah.
And that's an active misrepresentation. I'm not okay with it. That's government information. I hear over and over again companies that say, or from my relator, that the company has said, we decided to accept the risk. Excuse me? You don't accept the risk for the government. For me as a taxpayer, you don't get to accept the risk of letting that information get loose. Right? Now, I know what they really mean is we accept the risk that they'll catch us. But say it out loud that way, we accept the risk that we're caught, and that ought to bother you a little bit, right? Because there's no valid way to say we accept the risk of being infiltrated, exfiltrated, and generally, have our data stolen. It's not your battle.
I'd like to point out, too, just what a disadvantage the smaller companies have in that regard as well. When you have a larger defense contractor saying, I'm going to take the risk here. I'll be non-compliant. I'm going to say I'm compliant because the fine is probably not going to be as bad as the revenue that I'm going to generate. But what you're doing is you're unfairly bumping out legitimate companies that probably are compliant. They spent the dollars. They put the effort in. They're legitimately compliant, but you've stolen work from them through this fraudulent declaration.
Matt, talk to us about lessons learned for universities.
Like I said earlier, I don't think that Penn State is an unusual case. I think the problem in the university space is a lot more prevalent than people would think. Did have a chance to look at some universities that are doing it very well. They understand very clearly what's at stake and why it's important. And they assemble things like websites and resources for researchers. They put FAQs out and say, hey, it's this kind of information, or I'm not sure if it's COI or not. What do I do? So there are a handful, not very many, but there are a handful of universities that get it right.
Previously, when I spoke to the Georgia Tech folks that Julie is working with, one of the recommendations was to centralize, in your case, 84 IT labs or whatever that number was, is very difficult to be compliant across 84 different locations. And so the concept was, and I know this is also very difficult, but to centralize into maybe shared spaces. Or what do you think about that concept? And do you think it's actually practical?
Before we even got into the challenges of compliance at Penn State, I learned very quickly that centralization is really not going to be received well. And I understand research universities covering academics, research, and administration have different types of priorities. So instead of centralization, we really need to talk about standardization, those processes and metrics. They need to look the same. You need to understand what measuring stick you're using for things like performance and compliance. You also need to look at, we can't afford to get CMMC certification in 84 different IT environments. We can't afford to get all these controls in place, all the investments needed for every single area we could possibly be doing research. You need to drive the research into flexible solutions that are built on the standards, agreeable standards that allow the university to be compliant.
What advice for future whistleblowers would you give?
You're really taking your career into your own hands. And so be very careful, be very planful, have some flexibility, be ready to make some significant changes in your life if this is what you're about to do. There are a number of books out there that you can read too. I think I was sitting on an airplane and I was digging through, I think it was called the Whistleblower's Handbook, and reading about the stories of people that they had to do something similar, typically in the pharmaceutical industry, but how miserable their lives became, how challenged they began to be just in their family situations. And if you know that going into it, I think you've got a pretty good chance of heading some of those challenges off as well. But it will take a toll on you. Document the tar out everything. Don't be afraid to hang on to those emails so long as you're not violating your records management policies. Those are forms of documentation as well, where decisions are being made in emails sometimes. Those constitute as records. So document, build your timeline. Don't forget things. Even record just on paper when you had meetings so that you can explain, we talked about these things. This was the agenda at this meeting, so that you can say, we really did give it a shot. And that's not just useful just for opening a case. That's useful for going back internally too and saying, hey, look, this isn't just a sudden revelation here. This is something that we've been working on. You might not have been here as leadership transitioned over time, but I need you to understand it was important then, it's important now. Here's the progress that we've made. Here's where we stand. One of the questions you might ask too is, would you do it again if you had to? And the answer is yes. It's an obligation. Really, it's not easy, but absolutely, you have to do the right thing. This is one of these things that our nation depends on. It's our taxpayers that count on it too. So absolutely is the right thing to do.
Thank you. That's very helpful. And I'll have that link to the book you mentioned in the description, folks. So take a look at that. Julie, talk to us a bit more about getting to the settlement in this case, because I saw something months ago, the DOJ had declined to intervene, something like that. And then here we are with the settlement. What happened in between?
It was a bit of a misstatement to say that the Department of Justice declined. The FCA, the statute itself, gives the government 60 days to make an intervention decision. And then it can get extensions by requesting the court, by leave of court. Everybody who works in the space knows that's absurd. If I am lucky, I will have a team assembled on the government side, and they will have conducted their first interview of the relator within that first 60 days. But just think about it. This is big government we're talking about. You may be coordinating with state agencies. In this case, we had DARPA, we had NASA, we had, I believe, Army. If you look at the settling agencies, first you have to figure out who's involved. Then you have to alert all of those agencies so they can decide if they want to assign an agent. Then you have to find a day when all of those people can be on at least a Zoom. And in our case, we did a live interview with Matt and then had some people on virtually as well. So you have to assemble what I call alphabet soup, NCIS, DLI, all these folks. That takes 60 days. That's just, it's not reasonable. But that's something that as an FCA practitioner, I would love to see made more reasonable, because now you're off to the races asking the court for an extension. And the problem is it's not one court. You're in different districts, Northern District of Georgia, Eastern District of Pennsylvania. We had 2 different judges with different views on extensions. You don't know even when you get the same judge when they'll feel like, well, that's enough time, and want to pull the rug out from under the government. So it comes down into sort of when the judge will typically give an extension. In some districts, they at standard take a 6-month extension, and they'll do that, and it'll come to a point where either they're about ready, and they'll say in their motion for extension, they'll say, we think we're closing down here, but we need 6 more months. They give the court that kind of information, or the court will say, you've had enough time, wrap her up, we're kind of done. And that happened in Penn State, where we were like, excuse me? Like, this is a complex case. If it weren't a brand new cyber fraud initiative, the attorneys for Penn State were actually working with the Department of Justice on its investigation. Nobody was at loggerheads. And it doesn't make any sense to, the next step, if they truly decline, is it comes to us to decide if we want to prosecute it individually, which is, by the way, not a possibility with an arm of the state. So we would have to go through the motion to dismiss on whether it's an arm of the state. Maybe Penn State isn't an arm of the state, but that's a conversation for another day. We never reached that question in this case. But we go forth and ask the court for more time. The U.S. does, and we are asked if we oppose. We very, very rarely oppose, because we want the government, the defendant want the government, and we want the government, and the government wants to do a robust investigation, because if there's nothing there, if it's smoke and not fire, it doesn't help anybody to keep prosecuting it. We need the government to decide. This is the weird case where I'm telling you, Jacob, that there's a problem with your new car. And you have to decide, is there a problem? Do I care about that problem? Do I care enough to sue about that problem? And that's your decision, not mine, and not the defendant's. So, that we need to give them the space they need to make that call. Of course, I will say that when there's no deadline, then that things that can be done at any time are often done at no time.
Yes.
The maxim. So, having some kind of regular check-in with the court is not a bad thing. But when we get situations like Penn State, where the court says you're done, and neither the defendant nor the relator nor the Department of Justice felt that they were done, then what Department of Justice files is what we call a demi-declination, or a notice of no decision. So the government never declined the Penn State case. Okay. What they filed was something saying, you're saying we have to make a decision, and we refuse. We can't make a decision yet. They won't go on the record saying one way or the other. Well, the court, not to be outdone, says, fine, if you're not intervening, you're declining. And so it's treated from that point forward as a declined case. Now, in the Penn State matter, we had kind of this backup plan. We went and we agreed to magistrate jurisdiction, which is the magistrate judges are not Article III judges. They're not appointed by Congress. They're hired through the districts themselves. So they're a assistant judge, if that makes sense. It depends on the district, but they handle things like discovery disputes so that you can keep that running without bothering the main judge at the district judge level. And it's uncommon to agree to magistrate jurisdiction over something like this. But it had happened once before with an FCA case that had its time cut short. So we were assigned to the same magistrate, and that magistrate gave us the 180-day extension and told us to file a report in 180 days. So we sort of took those extensions while they continued their investigation. They did reach, as you saw, a settlement. I'm not able to say a whole lot about that. The bottom line is that the government never expressed disinterest in the Penn State case. They never declined it. They went forward with it, even in those circumstances where it would have been easy enough to just decline it and not giving us the time we need. And the fact that they did that, I think, speaks volumes to how important these issues are for the Department of Justice and for those agencies whose contracts they're trying to protect.
Well, Julie, going back to Georgia Tech, the DOJ decided to intervene. And from what I understand, Georgia Tech is working on a motion to dismiss.
So the first thing that happens in pretty much every FCA case is that the defendant moves to dismiss. And they do that because we're a fraud statute. We're subject to a special rule of the Rules of Civil Procedure, the Federal Rule of Civil Procedure number 9B. 9B says that you have to plead fraud with particularity. What that means is you have to give details about the fraud. It's contrary to most things in American jurisprudence. You can go in and say, Jacob sold me this lemon of a car and it was fraudulent inducement. You've got to say, well, what was the fraud? You have to say, well, he told me there were only 10,000 miles and it was 100,000 miles, or, that sort of thing. It's easy enough if it's, you selling me that lemon of a car that you've messed with the odometer, Mr. Hill. That's easy enough. I'm part of that transaction. I know the details. But when you bring to the government a case, let's say you're in a doctor's office, you may know that they're running tests they shouldn't be running just to bill them, but you might not know at the same time the billing part. Or you might know the billing part, but you might not know the medical piece. So when you take it to the government, that's part of what the government investigation is doing. And if the government goes forward, they have all the pieces. But if it's a decline case, relators won't. And even the government is held to that standard. So not surprisingly, the first thing that after the complaint and intervention was served, you normally have a relatively quick turnaround on filing a motion to dismiss. That'd be 60 days if you accept service as opposed to having to be served. But Georgia Tech and the U.S. worked out a briefing schedule that gave them extra time to write their complaint. So their motion to dismiss was filed beginning of last week, I think. And then they have until, I think we're in December before we're going to get the response. And then in February, we'll get the reply. So the government will go next and say why Georgia Tech is wrong. And then Georgia Tech will come back and say, no, we're really right. And then the judge may decide to set oral argument, in which case that'll be put on the calendar and he'll hear arguments in person. That's the chance for the judge to ask questions. If they have particular points that they're interested in, the court may not have questions and decide it on the briefing. We're not fully briefed until February, like mid to late February. We're not likely to get an answer for at least a month and maybe longer. If we do, I'll be pleasantly surprised. It's going to be up to the judge to review all the documentation, decide if they want our oral argument, make decisions down that line. But that's where we stand. So we have until probably spring. It'll be very interesting to see what the court rules. So I will say that on that motion to dismiss, I saw a lot of commentary on it on LinkedIn and otherwise, people thought it was kind of a strong response in the beginning as far as your evolving landscape came up again, and reasons why maybe they weren't getting CUI or they were only isolating CUI or all that sort of thing. But the motion to dismiss did absolutely nothing to address the broader allegations. So with that being said, I'm going to be surprised if the court dismisses based on this. I feel that the government complaint was very strong, and the motion to dismiss, to my eye, is not very strong. But we're going to flesh out in this litigation, which is what the law does. We're going to flesh out what are the rules, what are the standards in this new evolving world of cyber fraud. It meets the FCA. We'll see how it goes.
Well, thank you so much, both of you. I really appreciate your time coming on, telling this story. Matt, Julie, thank you so much. Julie, where can folks find you?
I am at FCA Counsel, False Claims Act Counsel, like a lawyer, COUNSEL, and you can find me on LinkedIn. I'd love to talk to anybody who is struggling with this. It's a free consult. We've talked about several things you need a lawyer to look at, including maybe it's not a problem. Maybe I can put your mind at ease with a conversation. Yeah. If you want to go forward, talking to me does not mean you have to go forward. It's just an opportunity to find out you're right, to be worried about what you're worried about. And if you are, then we can talk through those things Matt mentioned that you can get ahead of if you have good counsel on the front end.
All right, Matt, where can people find you?
You can certainly find me on LinkedIn if anybody wants to talk about their experience or even more about mine. You can find me there.
Thank you so much, both of you. Really appreciate your time. Hey, folks, hope you enjoyed that. If you want to see more, be sure to subscribe and then check out this video.